am Loren Speziale. I am one of the partners in the business services group. We've heard a lot about how to put non-compete agreements in place with different employees, executives who will be working for your business. The question often comes up, what happens when that employee decides to leave? And what steps can the business take in order to use that document to enforce and protect their rights? We've talked a lot about what businesses can do in order to protect their rights through contracts that include non-compete and non-solicitation provisions. The question then often comes up as far as what can a business do when that employee who has a contract decides to leave their employment, whether it be because of termination or they voluntarily decided to resign and go their separate ways. The business has a few different opportunities in deciding what path they want to take. First, obviously, they're going to evaluate whether or not they believe that employee is potentially a threat to the business as far as either taking clients with them to their new employer or soliciting those potential or current customers or even their own employees. If they decide that that employee is going into a whole different industry, they may decide it doesn't make sense. But what if that employee is actually going to a competitor? At that point, decisions need to be made as far as what steps can be taken with that contract that has been signed between the employee and the business. And the first step is making that employee aware of that continuing obligation that goes with them when they walk out that door to go to the new employer. Often that is done through a letter that simply reminds them of their continuing obligations to the company, that they're not to compete or solicit for the period of time in the agreement, and reminding them that their new employer may in fact be a competitor, which might be a violation of the agreement. If that employee decides that they are going to continue forward and work for that competitor, that may then require the business to send what we call a cease and desist letter. That letter will tell the employee again that they have a continuing obligation to the business, that they are working with a new employer who's a competitor, that it's a violation of their non-compete and their non-solicitation provisions, and that they have an obligation not to take any action that would harm the business. That letter often is sent not only to the employee, but to the new employer, so that employer knows that there is a restriction on what that new employee can or can't do. The response is varied. You may hear back from the employee advising that they're not competing and explain why they're not competing. You may not hear it back at all, or you may hear from the new employer to better understand what restrictions are in place. At that point, decisions have to be made as far as what you're going to do with regards to pursuing and enforcing your rights under the non-compete agreement. That may be further discussions with the employee and the new employer. It could be a carve-out where everyone agrees what that employee can or can't do for the new employer. There may be some limited release of the terms of the non-compete agreement that would allow that employee to do certain tasks for the new employer during the non-compete period. Or there may be the decision that a litigation needs to be filed in order to enforce your rights as a business in the non-compete in order to prevent solicitation and competition from happening, which would take customers, employees, or vendors from you because of that employee leaving. If the decision is made to litigate, that is typically started with the filing of a complaint and injunctive relief being sought, which means that the attorney handling that will go in and ask for the court to hear this matter immediately. And the reason they ask for that immediate hearing is because the damages are already starting. That employee is already starting to contact employees. They're contacting customers. They're trying to pull business and employees away from the business. And the ask of the court is, please make this stop immediately. and allow us some time to work out what's going to happen with regards to this employee and this new employer. Through that litigation, complaint is filed and they conduct what's called discovery to get more information about what the employee is doing and what the new employer is asking that employee to do. And a hearing will be conducted ultimately where a decision is made by the judge with regards to whether or not that employee can continue to work for that employer, needs to pay certain damages to the employer, or some other form of relief in order to protect the business. All of that is based upon a finding that there is actually enforceable non-compete in place, and the court saying that the business has a right to enforce that contract. At that point, there may be further litigation as far as damages that might have been incurred, but at that point, the goal would be to try to stop that competitive action by the employee who has left the business. Once you get to court, if the court first finds that there's an enforceable non-compete, non-solicitation agreement, and that employee continues to violate it by working for the new employer, the business can go back into the court and ask for an enforcement of that order. As part of that, they would ask for damages, which might be their actual loss of business and revenues and other damages that they might suffer as a result of the continuing competitive action. They could also ask that the court extend the period of the non-compete. So if the non-compete is for 6 months and it's taken 3 months to get an order saying that they've been violating it, they can ask the court to extend it for 6 months from the date of that order saying that there is a non-compete in place. That way the employer has the full period of time in order to try to protect and recapture the business that the employee has gone after.